Hello there, and thanks for joining us in Project Justice this week. I am Utubel Moran. On this episode, we open at the courts because this is where a potentially highly charged political case is likely to take place in a few moments' time. And that has to do with the continued absence of President Buhari from office. Although the president had transmitted power to his vice president as acting president, questions still remain as to how long the president can be away before Section 144 of the Constitution 1999 is activated. If there was uncertainty as to the state of health of the president, he did not leave anybody in doubt when, on his return last April, he admitted he's never been that ill. The uncertainty, however, lies in the nature of illness of the president. That is where the president has been silent, and his handlers have been quite taciturn. The question, however, remains, do Nigerians deserve to know? Is it a legal constitutional matter? Well, the Nigerian Constitution talks about a situation of permanent incapacity, which can necessitate a president or vice president to leave office. Legal experts believe the drafters of the Constitution were mindful of the fact that a country needs a fit president to run the affairs of the country. But what does the Constitution really say? Well, in the context of the present situation, some may argue that the president has been largely absent and played a negligible role in the affairs of governance for the most part of 2017 alone. Between January and March, President Buhari spent 57 days in London, 49 of which was on medicals. Between May and June 2017, the president has been away on medicals for another 54 days. So in 6 months of approximately 182 days, the president has spent about 103 days off base. That's about 60% of time off duty. It is on this basis that a Nigerian, Toyin Daudu, has initiated a case in court. A lawyer for the plaintiff, Frank Tietie, joins me now on Project Justice. Frank, thanks to have you join us.
It's a pleasure.
What is this case essentially about?
Well, I don't think that any reasonable set of people as a country or as a nation would tolerate the fact that their president has been away in a foreign land and they don't know how much he's faring there, whether he's well or not well, and then it's beyond whether he's well or not. It is whether he's actually in control of the government. Of course, he has done well by transmitting a letter to the National Assembly, and then the vice president is actually acting as a president. But the continued, secrecy of the status of his health is worrisome to any set of reasonable citizens. Now, what this case essentially wants to do is to, create the impression that, look, the health of the president is not actually a private matter. It's a matter that is of national concern, and that as a people that are governed by law, as a republic, each individual or the individual, collective citizenry can actually ask questions about the health of the president, and then they will be informed. Now, that opacity, it's what this case intends to remove. History is replete with a number of, presidents that have been ill, and then there is constant information being given to the citizenry. Even when President Reagan there was an attempted assassination against President Reagan. Every minute, or when he went through that operation, was in fact, there were times that it was even televised. So we've gone past the era of secrecy, and that the health of the president is a matter of national concern. People can't even pray for the president better if they are aware of the status of the president. And beyond that, let's now even take a look at the politics, the politics of the president's health. Now, you see, in a situation where there is no knowledge about the status of the president's health, then we now become in a state of quandary, especially where we have a vice president who is now acting, who cannot actually take charge because of the restrictions of politics, not because of the restrictions of law. He's actually acting president. He does have the powers to act as if he's president. But, it means the questions of two questions there. Now, Is it possible for that the president is so unwell to the extent that he cannot continue as president? Then should he resign? Now, his supporters want to know. And in that regard, to enable the country move forward beyond the illness of the president. So the whole essence of this case is to remove that secrecy, that opacity surrounding the health of the president. It's not normal and it's not responsible as a people and as a country for us to continue to be in the dark regarding the health status of our president.
Some would say that the Constitution, Section 144, provides the process through which such questions on the health or medical status of the president can be found out. And that has to do with members of the Federal Executive Council activating the sections of that provision.
It is clear now that there is a mischief in that provision of the Constitution. Because here we are. There's a sort of people who should actually determine whether the president is fit enough medically, health-wise, to continue to discharge the responsibility of the office of the President of the Federal Republic of Nigeria. These persons are not medical doctors. Why do you give them the provision, why you give them the responsibility to determine a medical case, whereas they are politicians? Now, so there is some measure of fault there. But that calls for interpretation, because the same Section 144, by virtue of Section 144, subsection 4, provides for the appointment of a medical panel. That's a medical panel that was referred to as subsection 1 of Section 144, meaning that if you look at the intention of the Section 144, you wouldn't regard the resolution of the Executive Council as a condition precedent, because that will not be reasonable. So where there is a medical...
Why would it not be reasonable?
It will not be reasonable because the Executive Council is actually made up of more, even though they are medical doctors, trained medical doctors there, but they are appointees of the president who act in the political capacity. Now, it cannot be fair that a people appointed by the president will now turn around again and declare that the president is unfit. It's a bit unlikely. Now, it would demand an extraordinary form of patriotism, which may not be wanting anyway. But in order not to leave that to any form of guesswork, it is only reasonable that where that same Section 144 has made provisions for a medical panel, a set of people trained in medicine, to now make a determination. That means that the possibility of the Executive Council even making a vote on that resolution would be now based on the provision or on the work that that medical panel has done. So we see that mischief there, and we believe that only the court can look into it and actually, unravel the true intention of the Constitution by virtue of the provisions of Section 144.
You say it's not quite possible for a member of the Federal Executive Council to move such a motion seeking questions. But we've seen situations like that in the past. In the case of former President Umaru Musa Yar'Adua, we had a member of the Federal Executive Council then, talking about Dora Akunyili, who said clearly that the president is not well.
Well, she tendered a memo for discussion at the Federal Executive Council meeting. Now, that wasn't pursued to the conclusion. You know how it was resolved. It was resolved by the invocation of the doctrine of necessity on the part of the National Assembly. Now, that is creating, by virtue of exigency. We do not need that. Now, there's likely not going to be a repeat of that in this situation. Now, we wouldn't expect. Well, there wasn't actually a vote by the Executive Council at that time, and then we had a resolution by the majority of the members of the Federal Executive Council saying that, look, the president is unfit. Now, we have an entirely different scenario. The president has transmitted power to the vice president, unlike the other scenario where the president didn't do that. I'm referring to President Umaru Yar'Adua. He didn't do that. So we're really in a state of quagmire. But here we are. Their nerves are not really frayed. We are calm. We just want a situation where we are a people. We appear to be a people governed by law. Now, here we are. The president cannot continue to stay away from his subjects, from the country, from his job as the President of the Federal Republic of Nigeria for that number of days, and then there is no sufficient explanation as to what is ailing the president. Now, as citizens, we are entitled to know. And it's a right to know. It's a right of every citizen to know the health status of the president. And if it is that state, if it gets to that state where the president can no longer, it doesn't need to be such a debilitating illness, but where it gets to that point where he can no longer, sufficiently discharge the responsibilities as the president of the Federal Republic of Nigeria, then there are pieces of advice that can be rendered to him that he should resign, for example, and where it is sufficiently clear to the larger majority of the people's representative in the National Assembly, particularly in the Senate, that look, this man, however, patriotic that he is, give it to him, he can no longer discharge these responsibilities. And as such, he would be given the opportunity to resign. And if not, he will be impeached.
Have we gotten to that stage, in your opinion?
We haven't reached that stage because we are in the dark. We don't have sufficient knowledge about what is ailing our president. And I think that even the president himself has no right to keep it away from Nigerians. He needs to tell Nigerians he belongs to this country. He belongs to every citizen. Now, even those that voted for him and those that didn't vote for him, he's our president. We don't have any other president but he. And we don't have to pretend that the acting president is fettered. He has some restrictions in the political dispensation of the powers that he has currently as the acting president of Nigeria. It is different when he is fully president. Whereas if we know for certain that our president will be coming back, because there is nothing wrong in getting a medical advice from the doctors of the president that look, the president may be staying away for 100 days, but certainly he will be coming back and he will be fit and hale and hearty to continue his job. Now that would put a lot of minds at rest. Now, not to know the current health status of the president, no, it is not fair to the citizenry. And I think that's what has motivated Mr. Tony Daudu all the way from the United States. Well, of course, he worked so hard. He has proved it that he personally campaigned for the president. He believed the president was a deliverer from the economic quagmire that we had in the preceding administration, and that he is not saying it. And then he believes that the president cannot also, the health of the president cannot also stand in the way. Now, we are in a threshold of very, very decisive moments in our country's history. Now, only the person of the president, only the charisma that he has can actually give us a direction at this time. We need our president to be back. And even if it's not around, we need to know that our president will come back hale and hearty and that he will take back the reins of governance. But by the time we don't know anything, now you see, there will be this sort of inertia that will pervade the business of governance, and we don't want that.
Now, you have joined the Senate President as the first defendant in this case.
Yes.
What prayers are sought against the Senate President?
Oh, well, the first and foremost, we want the court to declare that the Senate President does have the power, under the provisions of Section 144, to constitute a medical panel to determine the health status of the president as to whether he is fit, whether he is capable of discharging the functions of the office of the President of the Federal Republic of Nigeria. Now, he has to do that irrespective of whether the Executive Council of the Federation has voted on a resolution.
That was about to be my question, because the process in line with Section 144 actually starts with the Federal Executive Council. Where the Federal Executive Council does not take that step, can the court compel the Senate President to take that step?
Now, look at the scenarios here. Now, where it emanates from the Executive Council of the Federation that the president is no longer capable of discharging his functions, there needs to be a verification by a panel set up by the president of the Senate. Now, the question now is different. Now, can't a citizen ask questions about the health status of his president? And when he does ask question about the health status of the president, who would determine that health status? It is the medical panel. It can only be the medical panel set up by the Senate President and no one else. Because that same provision of Section 144 insists that the chief physician of the president must be a member of that panel set up by the Senate President.
Would we not be jumping the gun, Frank Tete? That's what my question is.
Certainly not. If the Federal Executive Council has not deemed it fit, has not seen it necessary to vote on the resolution, the question now is, can't a citizen now ask a question, where is my president and what is ailing my president? When he asks that question, who would supply that answer? Would the answer come from the Executive Council or a medical panel? And it is not for fun that Section 144 makes provision for a medical panel. So whenever there are medical questions to be asked regarding the health of the president, it can only be that medical panel referred to in Section 144. And that's the reason why we made reference to Section 10.
It's Nigeria first UN permanent representatives,
which is a statute too. Now, what you do is, whenever a duty has been assigned to any authority to do that duty at a particular time. Now, for all intents and purposes, where there are circumstances that necessitate the performance of such duty, that authority can carry out that duty. So the question now is, we are not trying to determine whether the president is hale and hearty enough for him to continue to discharge the functions of the office of the president. The question now is, simply tell us the health status of the president. Who do you ask? You can only ask a set of medical doctors, and the Constitution didn't make a mistake. It contemplated that there would be a time the health status beyond the resolution that comes from the Federal Executive Council. Whenever there is a question as to the health status of the president, there can only be a medical panel that has been referred to by the Constitution that can be set up only by the Senate President. That's the argument.
We'll wait and see how this pans out, Frank Tese. Thank you so much for your time.
You're welcome.
Well, another lawyer has disagreed with the suit and the questions for determination raised therein. You'll meet him after this short break.
The Chief Justice of Nigeria, Walter Onogen, has advised Nigerians, especially those in governance, to do away with impunity and uphold the rules of engagement in the line of duties, warning that the law will not spare anyone found guilty, no matter how highly placed. Justice Onoge gave the advice in Calabar during a reception organized in his honor by the Cross River State government as the first indigene of the state to head the nation's judiciary. A former governor of Jigawa State, Senator Saminu Turaki, has been arrested by agents of the Economic and Financial Crimes Commission, EFCC, following the order of a high court in Dutse, Abuja. It was picked up at the venue of a public presentation of a book on Brigadier Zakaria Mai Malari, the first regular combatant officer in the Nigerian Army in Abuja. Before the arrest, EFCC had declared Turaki wanted for failing to present himself for trial since 2011 before the High Court Dutse on 36-count charges on corruption and misappropriation of public funds. The Federal High Court in Abuja has discharged Senator Ali Udome from the 4-count terrorism charge brought against him by the federal government in 2011. Udome, representing Borno South Senatorial District, was set free on Tuesday by Justice Gabriel Kolawole of the Federal High Court in Abuja on grounds that no prima facie was established against him. The federal government has arraigned 2 Chinese and a Nigerian before a federal high court in Abuja on allegations of criminal conspiracy, forgery, and illegal transfer of funds to the tune of about 2.5 billion naira. The defendants are Ajun, Leon Yangzin, and Obi Anthony Chibuzo were arraigned on the 15-count amended charge by the Inspector General of Police. The defendants pleaded not guilty to the 15-count charge preferred against them and were admitted to bail in the sum of 100 million naira each and sureties in like sum. The All Progressive Congress APC Kogi State Chapter and 12 others have asked the Federal High Court in Abuja to stop the Independent National Electoral Commission (INEC) from commencing the recall process of Senator Dino Melaye. In an originating summons filed before the court, the Kogi APC want the court to determine whether the provisions of Section 68 and 69 of the 1999 Constitution, the party can validly recall Dino from the Senate upon an invalid petition presented to the chairman of INEC.
Up next is Daniel Bwala, a member of Lincoln's Inn, and here is his take on the suit filed before the court as it has to do with the health status of the president.
If I have to give a very straight answer, I would say no, because if you look at the provision of Section 144 of the Constitution, you will see that it says the president or the vice president will cease to act in that capacity, cease to function in that office if there is a 2/3 majority resolution by all executive members of the Executive Council, right? And then that notice will be given to the National Assembly. So, and the Supreme Court has held that the word "and" means it's mandatory. That means it is not just enough for the National Assembly or the Senate President to act without a resolution from the members of the Federal Executive Council. So, no, the National Assembly cannot be compelled to act without a resolution by the members of the Executive Council. And it is intriguing that the resolution of the Federal Executive Council is not even a simple majority. The Constitution states in clear terms 2/3 majority of all the members. So all of the members have to be seated, all of the members have to vote, and then you have 2/3 majority from them before the National Assembly can act. Without that, it will be difficult. And the case is even more difficult by the fact that if it were a situation where, for example, the president traveled out of the country, or he's sick, he's incapable of performing his duty, and has not transferred power, and some members of the Federal Executive Council are already calling for a resolution, there is a confusion as to where, then in the circumstance, any of them can have a local standard to say, okay, they can approach the court, or they can write a letter to the National Assembly to say, use your authority or position to do that. But in this case, the president has transferred power, so the case is even more difficult, and if you ask me, I would say near impossible.
At what point is President's continued medical absence going to raise an alarm bell as to his capacity or incapacity to function as president?
Constitutionally, the concern is only raised if, for example, there is a delay, ineffectiveness, or no proper governance. And a typical picture is if, for example, President Buhari was unable to transmit power and he travels abroad. So that means there is the vice president does not have the full capacity of the president to be able to carry out the function. Then that will be an alarm bell for which it will call for intervention. But in this case, he has transferred power. So however long he stays abroad for treatment, I do not think constitutionally that is going to be a blockade or is going to raise an alarm for determination of itself, so long as his absence does not affect governance. And in this case, it doesn't look so. The Constitution is not very open about that. And that's because if you look at the Section 144 and you read down, you will see the word permanent incapacity of the body and mind. It means that the situation has to be precarious. If you want to give a literal interpretation of permanent incapacity of the body and mind, then the president does not even qualify to be placed in that position where you would say he is permanently incapable. Because somebody who has gone for treatment and comes back to a while and goes back for treatment cannot be considered as being permanently incapable of carrying out the function. So Constitution is not clear about that. And as long as the full powers has been transmitted to the vice president, there is no need for alarm.
In other words, it can stay as long.
Yes, it can stay. Some people argue that they look at other provisions of the law where if the president, for example, stays for as long as a certain period, like 21 days or the rest, they are going to raise question as regarding his absence. But when power is transmitted, I hold the view that in that capacity, you cannot say that you are going to invoke that part of the Constitution to raise an alarm. The most important thing the Constitution contemplates is governance. The absence of the president or vice should not affect governance. And the question we must all ask ourselves is, his absence, is it affecting governance? The answer is no.
When no member of the Fed finds it fit to raise questions, can't the doctrine of necessity be invoked?
It is not applicable here. It was applicable in the case of Yaradua because he traveled for medical treatment and did not transfer power at the time he was traveling. So the then Vice President, President Goodluck Jonathan, was limited because if you look at Section 145, 46, 47, you will see the functions of the Vice President are only the things that the particular functions or assignment that the President gives to him. But when power is transmitted pursuant to the provision of the Constitution, then that means everything the President can do, the Vice President can now do in acting capacity. So if you look at the literal interpretation of that, then in the circumstance, you cannot apply the doctrine of necessity because power has been transmitted, governance is on course. So I do not think that it is applicable in the circumstance. It was applicable in the time of Jonathan, and the National Assembly corrected that there must be a transmission of power before the president travels. And in this case, he did that. So I consider the calls for the determination of his health as being mischievous. I see that as being peddled by people. I wouldn't say people that are sponsored by some political, big weights. Sometimes people honestly will want to develop the law, or they have honest questions. But even I heard of somebody who has filed an action in the court of law seeking for the court to mandate the Senate President to constitute a medical panel. That person is not a member of the National Assembly, not a member of the Executive Council. In the eyes of the law, it's a meddlesome interloper.
Well, the case in question has yet to be assigned, but it promises to be quite an exciting politically charged case that will indeed deepen Nigeria's jurisprudence. And Project Justice will be on hand to bring you all the details as it develops. Well, that's the show for this week. Be sure to follow us on all our social media platforms, on Twitter, on Facebook, and view us on YouTube. And on behalf of the entire production team, I am Utabel Moran. I'll see you next week.